So in the ongoing battle between California, Uber, Postmates, and the gig companies, this is a great article. I'm also going to leave the link for you below. Uber Postmates driver loses court challenge to California's AB5 law. Let's jump right in. I'm reporting here from my bed. I had a bad accident, so excuse the background. This is not the office, but what's most important, obviously, is the content. Although AB5 remains a non-factor for now in the California trucking industry, the body of legal cases on its implementation continues to grow, and so far its backers appear to be winning. The latest decision favoring the backers of AB5 came down last week when a federal district court judge in California dismissed a constitutional challenge to the law brought by Uber Technologies and two drivers from food delivery service Postmates. Uber announced in July its intention to acquire Postmates. It is the second court decision in roughly 6 weeks to go against the companies and individuals fighting the imposition of AB5 among delivery drivers. And while AB5 remains walled off from the trucking sector due to a preliminary injunction in place since the beginning of the year, the decisions being handed down now could be setting precedents for what surely would be a new legal battle if the protections to trucking under the so-called F4A Act are yanked out in an ongoing lawsuit first brought by the California Trucking Association. AB5 went into effect January the 1st. We know that. It seeks to put into law the provisions of the Dynamex decision from 2018. There are numerous categories of independent contractors who have had an exemption carved out for them. That list got longer earlier this week when a revision of the law gave exemptions to workers such as freelance writers and translators. In the Uber Postmates case, an attempt in February by the plaintiffs to be granted a preliminary injunction against the law failed. Several grounds for the challenge: the suit by Uber and the drivers challenged the constitutionality of AB5 on several grounds, including equal protection under the laws and due process, in part because of the many exemptions granted to a myriad of categories but not drivers. The plaintiffs in the case charged that AB5 violated several legal protections because it was specifically targeted at drivers, including the truck drivers who so far have been protected from the law. The dismissal handed down by Federal District Court Judge Dolly G. said many of the exemptions cited by the Uber and the Postmates drivers are not exemptions at all, and that the ABC test still applies to the relationship between a subcontractor and the worker, such as that between a construction company and a construction worker, as opposed to the relationship between the contractor and the subcontractor. There are jobs that are exempt that require licenses granted by the state. Judge G said the transportation jobs at the heart of the lawsuit require distinctly different training, accreditation, and industry protective considerations than the professional licenses exempted in AB5. Plaintiffs do not plausibly allege that there is no rational reason to treat a transportation business license differently from a license to practice medicine or law, G wrote. G conceded in the list of exemptions might not be perfect, but cited precedents in noting that the old adage holds, the perfect is the enemy of the good. She cited an earlier decision that held that a state legislature in writing a law does not run the risk of losing an entire remedial scheme simply because it failed, through inadvertence or otherwise. To cover every evil that might conceivably have been attacked, the legislator is given leeway to impose some admittedly arbitrary line drawing, she wrote. So while the media coverage of AB5 overwhelmingly has focused on Uber and Lyft, fueled in part by comments made by the legislation keybackers, G was not swayed that the law was unconstitutional because it could be seen as singling out a particular class of worker-employee relationship. but she dismissed the charge, noting that earlier court decisions have held that a plaintiff cannot prove invidious discrimination simply by alleging that legislators responded to lobbying efforts because accommodating one interest group is not equivalent to intentionally harming another. So I'm going to leave the link for you. Pretty dry subject here, but it just shows you, it gives you a really good perspective of like the laws, what Uber and Lyft are trying, right, to overturn this, what AB5 stands for, what California stands for. It puts it all into perspective. And I'm going to put the article with the link beneath this video. I also want to give a shout out to my sponsor, Cova. Cova is a gig protection plan. You get 1 month free if you use my link below. These are portable benefits for gig workers: paid time off, sick leave, 24/7 health service, legal protection, automatic mileage tracking, all the benefits and perks you need in one membership starting at $7 a month. Look at all the companies that they cover there. Only $7 a month, ladies and gentlemen. Do you fall in any of those companies, gig working companies? Check it out. Just follow the link below. You get 1 month free. Obviously, you have your auto insurance, you have your medical insurance, but you also want to make sure that you have a great gig protection plan in place. So they think of all the eventualities that could go wrong. They kick in, they protect you, and it's really worthwhile visiting that dashboard and finding out what Cova does for you. Have a great day, and your feedback, please.